Hi, everybody, and welcome. This is panel number 3 and our last panel of the day, Separating from the Military and the Policy Implications of Bad Paper. I'm Isabel Ord. I'm a co-chair of the Class Action Litigation Practice and a co-chair of the Financial Services Sector at DLA Piper, and also one of DLA Piper's co-chairs for our Veterans Task Force Legal Issues Working Group, which has been looking at some of the things we're talking about today. And I'm a former JAG officer, so I know a good bit about bad paper and how sometimes that is the way that a veteran ends up leaving the service. I'm excited to introduce our last set of panelists who will address separation from the military and the important policy implications of what is called bad paper by the veterans services community. Before that, I'd like to remind everyone listening that our team will drop links in the Zoom chat for resources that the program participants identify in advance. For our guests following on Facebook, we'll drop the same links in the comments section. One of our goals today is to generate recommendations for how to better connect veterans to civil legal services. We invite you to share any resources or information in the Zoom chat or in the comments section. And if time permits, we'll be taking questions from those who have joined on Zoom at the end of the panel. Please indicate in the Zoom chat that you would like to ask a question or to make a remark, and the moderator will call on you so we can get to as many people as possible in the order that people wrote in. It is now my sincere pleasure to introduce to you our panelists for this program. Brian Thompson, a staff attorney in the Office of the General Counsel at the Department of Veterans Affairs. He has litigated several cases before the U.S. Court of Appeals for Veterans Claims and the Court of Appeals for the Federal Circuit. Dana Montalto is a clinical instructor at the Veterans Legal Clinic in the Legal Services Center of Harvard Law School. She founded the Veterans Justice Pro Bono Partnership and has authored various articles on veterans with bad paper discharges. Also, Major Stephen Stokes, a staff judge advocate at the Idaho National Guard and chair of the Idaho Military Legal Alliance, and is on the Idaho State Bar Pro Bono Commission. And our moderator for this panel is Stephanie Davis, our own Stephanie Davis. She is a senior assistant general counsel at the Legal Services Corporation and LSC's lead on the Veterans Task Force. Stephanie, will you take us out?
Wonderful. Thank you for that kind introduction, Isabel. And we'll go ahead and jump in with our first panelist. So this question is for Major Stokes. We've been talking for the past several months about veterans discharged from the military, but we haven't discussed as a group how the military determines a service member's discharge status. I think that's a pretty opaque process to those of us on the outside. Could you tell us from your experience how that process works and what factors the military considers in making discharge decisions?
Sure. Thank you, Stephanie, and the members of LSC. It's an honor and a pleasure to be here with you all today. I have to make a couple of standard disclaimers before I jump into my comments. The first one is there's obviously a wide array of experience and expertise and professionalism on the line, from civilian partners to former judge advocates, and I don't want to insult anybody's intelligence, and so my comments are going to be very high level, just 30,000 foot view on separations of bad paper. In addition, everything that I'm going to say is my own personal opinion, and anything I say doesn't reflect the Idaho National Guard's opinion, the Department of the Army, or the Department of Defense. Okay, so with that, I think everybody is generally familiar with the categorizations of discharge, but I just wanted to review them for the group. And there are 5 general types of discharge. The first one is entry-level status, and that is for unsatisfactory performance or conduct while in an entry-level status. So a recruit comes to the service and does not do well in their basic training, and they are separated without any sort of characterized separation. The second is honorable, and that's appropriate when the quality of the soldier's service generally has met the standards of acceptable conduct and performance of duty for military personnel. There's general discharge under honorable conditions, which is issued to a soldier whose military record or a military member whose record is satisfactory but is not sufficiently meritorious to warrant an honorable discharge. The third kind is other than honorable, or OTH, as we refer to it in the military, or in the Army, excuse me. Other branches call it other things, but for the rest of this conversation, I'm going to refer to it as an OTH. And that's authorized for a pattern of behavior or one or more acts or omissions that constitute a significant departure from the conduct expected of military members. And it's only permitted if the basis for separation specifically authorizes it, So for misconduct, fraudulent entry, unsatisfactory performance, security reasons, or in lieu of trial by court-martial. And then the last two are kind of outside of the scope of this conversation, but they definitely do have an impact. The first one is a bad conduct discharge, and the last one is a dishonorable discharge. And those are only authorized when they have been adjudicated as part of a sentence in a court-martial. So when we're talking about the process, we're talking about basic administrative law. And if you remember from law school days, whenever an agency decides to take adverse action against someone, a citizen, the minimum requirements under the Constitution are notice of proposed adverse action and a meaningful opportunity to respond. And so when we're talking about being separated from the military with bad paper, quote unquote, every service member is entitled to the basis for the separation in the notification, and then the advisement of rights. And I'll come back to a little bit to that in detail later, because I know there's going to be a question for me about that. And then they're also entitled to a meaningful opportunity to respond. And when we're talking about an OTH discharge, that's not authorized unless a member goes to an actual board, an administrative hearing presided over by a panel, or they waive their rights. Okay, so when we're talking about considerations for characterization, there are some regulations that are at play here, and I prepared a little PowerPoint presentation and I sent that out ahead of time. And if anybody doesn't get that, just let me know and I'll forward it to you directly. But like everything else in the DoD, it's governed by regulation. So if you look at the Department of Defense Instruction 1334.14, Enclosure 4, it talks about guidelines for separation and characterization. And it's very clear in the DoD that characterization of service is of great significance to a member. It must accurately reflect the nature of service performed. And it goes on to say eligibility for veterans benefits provided by law, eligibility for reentry to the military service, and acceptability of employment in the civilian community may greatly be affected by service characterization, which we all know. And so when we're looking at characterization, some factors that commanders are supposed to look at. Go back one slide, please. So characterization, if you look at that last bullet, characterization is supposed to be based on the quality of the soldier or the member's service, including the reason for separation. And so it's a whole picture analysis at the time of separation. Go forward to the next one. So when commanders are looking at a situation, they're going to look at those factors. They're going to look at the quality of the soldier's service. They're going to look at whether or not the conduct brought discredit on the armed forces. They're going to look at conduct in the civilian community, whether or not that's a justifiable basis for the characterization. Specific circumstances. It's not, generally it's supposed to be based on a pattern of behavior and not a single incident, but like it says right there, there are times when conduct or performance is so egregious that it forms the basis for an OTH characterization. And then you can see that last bullet point. So what are the factors regarding that specific member of the military that would mitigate against an adverse characterization of service? So go to the next slide, please. When we're talking about OTHs specifically, these are some additional factors that commanders have to look at when deciding whether or not to recommend an OTH. Use of force or violence, abuse of position of trust, and you can read the rest. But if you look closely at those factors, the OTH characterization of service does not just happen. There has to be a sufficient basis for it, and the recommending commander has to weigh all of those factors before making a recommendation to the separation authority. And then once the initiating commander gives that recommendation, the member is notified and is given an opportunity to respond.
Excellent. Thank you, Major Stokes. So when a service member is facing an involuntary discharge, what information do they receive about the effect of that discharge status on their eligibility for veterans benefits? And is that a factor that can that the discharge board can consider when they're deciding how to approach the proceedings, or that they can consider when they're deciding how to approach the proceedings?
Okay, thanks. So if you go to the next slide, so these are the things that have to be in a notification to a member. There has to be the specific allegations forming the basis of separation. The member is notified of the characterization of service and the impact on that characterization. And those quotes right there are some exact verbiage that come out of Army and Air Force instructions. And in fact, if you look at that third bullet there, there's a regulatory requirement for, at least in the Air Force and the Coast Guard, to conduct annual or regular briefings to airmen and Coast Guardsmen on the procedure for discharge, characterizations of service, and the impact of that characterization on their future life. They're also notified of a right to consult with counsel, submit statements. They get a copy of all relevant facts or investigations if there was one done. And then, like it says right there, they're entitled to a hearing if they have more than 6 years of service, or if an OTH characterization is recommended. So I guess I'll say that service members now, and this can be up for debate, and I'm happy to field questions from the group. But when at least on the Army side, when we notify somebody, they are made aware that the characterization of service will have an impact on their future, both with regard to benefits and with regard to civilian employment and with regard to civilian stigma. Now, when a board is considering the evidence and is making a recommendation, findings of fact and recommendations to the deciding official, generally speaking, the board is not allowed to consider the impact of benefits when they're conducting their analysis. And in fact, we just went around on this on a board that we did earlier this summer. The board heard the evidence from the government. They heard the evidence from the respondent. They received their panel instructions from the legal advisor. And then the very first question out of the board's mouth was, well, how does this impact benefits? And at least in the Army regulation, it doesn't say, the regulatory guidance does not say, thou shalt consider benefits, but it does say, I'm paraphrasing here, it does say that characterization of service is a very big deal to service members. And so boards are encouraged, rightfully so, to weigh the facts carefully and conduct their analysis carefully, so that they don't just pencil whip it and send somebody down the road in a situation where they're going to have trouble.
I now want to turn to the post-discharge part and talking to Brian about the VA and how they consider things. So Brian, could you tell us, whether the type of status or the characterization is someone ineligible for all benefits if they have an other than honorable discharge, or does the discharge characterization affect which benefits they are eligible for?
Sure. Thanks for having me, and it's a pleasure to speak with anyone. A version of the disclaimer, I guess, applies to me too. And when I was trying to put together how to talk about this issue in 5 minutes, I really wasn't able to. There's a lot of nuance in this, and so I'm just trying to hit the 30,000-foot overview, and I'm trying to articulate what I think of, how I conceptualize this. This is sort of a roadmap, and so what I'm saying is how I think of it, and hopefully it'll be helpful to people. But it's certainly not a statement by the Department of Veterans Affairs or anything along those lines. For me, the starting point is the default rule, the default setting. And generally speaking, someone who served in the military will have a number of benefits that attach and are potentially available for them if they are considered a veteran, and that's a 38 U.S.C. 101. That's a statutorily defined term, and Congress did not match up VA's authority with DOD's discharges, the Department of Defense discharge. So we have conditions other than dishonorable, but conditions, there's, some variability around that. And we don't think of it as being necessarily automatic in every situation. If the veteran has one of the 5 characters of discharge that Major Stokes was talking about, that everything's going to be, clear just based on that. There's some adjudication that VA has to do after the fact in some instances, and there are some things that are pretty easy and pretty clear. So the best case scenario is in honorable discharge, and you pretty much get everything. You have access, at least on the character of discharge, to everything that VA has. And the GI Bill is a benefit that you have to have an honorable discharge for. If you have a generally a good discharge, a general discharge, or something like that, you still don't get the GI Bill. And there are always exceptions, and there are always wrinkles in all of this. And the VA system is sometimes, I think, complex because everybody wants to give everyone who served every chance possible. Generally, the GI Bill, you're not going to be able to, the veteran won't be able to get that benefit unless they have an honorable. But there are some other educational programs that they may qualify for, even though they don't have an honorable. But the default setting, again, is if you're other than dishonorable, you're a veteran, and if you're a veteran, you're going to get most benefits. The GI Bill is an example where Congress kind of said, you need more than that, and so they opted out on the high side. Just veteran status isn't enough. There are other examples, and some of these are relatively recent, that Congress has gone the other direction, and they've said, we're not so worried about your character of discharge, and we're going to create a little bit different wrinkle on it. And the two big ones are, there's some mental health treatment that is available that doesn't even use the word veteran in the statutory provision. It says former member of armed services, and it has its own way of dealing with the character of discharge issue. Another example is homeless veterans, and that is the one that I was thinking of that is I think relatively recent. And it provides a different definition of a homeless veteran, and it handles the issue of other than honorable or bad conduct discharge a little bit differently, and so it can become a little broader. And so there are some benefits that people who served may be able to obtain, even though they don't meet the definition, the statutory definition as adjudicated by VA for veteran status. And the one that might be sort of most useful or broadest applicability is there are times where a veteran can get health care even though they might not be able to get compensation benefits or disability benefits or that kind of thing based on their character of discharge. And the Veterans Health Administration, VHA, has sort of gone a little bit broader with other than honorable discharges, and for the most part, those are based on regulation, or you might be able to get a healthcare even though you're not getting compensation benefits based on your character of discharge. And that, I think, was more than 5 minutes, and it's barely scratching the surface, frankly. There's a lot of nuance in it, and there's there are exceptions like insanity, and Major Stokes was talking about sort of court martials, and there's really just a lot here. It's a complex issue, and I don't think anyone in Congress or VA is looking to lightly disregard someone's service. But the standards are out there and they do exist, and it's potentially relevant. And it definitely can be a threshold issue whether or not the character of discharge meets certain thresholds.
And so when VA determines that a veteran is not eligible for a service or benefit, does VA provide either information or referrals to a veteran service organization or a legal aid provider who can help them appeal an adverse determination, or do you provide any sort of assistance in that regard?
There are two lines there. One, the duty to assist, which is a statutory and regulatory animal, absolutely applies when you're making a claim for benefits, when someone is making a claim for benefits. And it really is no different conceptually for any missing element. So if that missing element for your claim is, the character of discharge, then the duty to assist, I think, applies to that. And potentially, getting a medical exam, certainly getting records. There are a variety of different things that VA that would fall within that category of, the duty to assist on that claim. But in terms of trying to help correct or petition the military to improve your character of discharge, it's a little bit like the referrals to representation. VA has a number of resources, and it has a webpage that it tries to take a veteran through. What department did you serve? What branch of the military did you serve in? This is where these resources are, and that kind of thing. But that's not really part of the adjudicatory process for benefits. That's trying to support veterans more generally. And so similarly, in the context of representatives, VA has a variety of materials about representatives and pro bono and resources that veterans can use. But that's not something that necessarily we would say, oh, here's some attorneys in your area or a VSO that you might want to look at with regards to a specific claim. That's just broader based information that is out there that VA tries to support people.
Now we've heard from the military side and the VA side about how their respective services agencies fit into the process of having helping someone transition out of the military into veteran status, and then considering the issues that they may face in trying to obtain benefits. And so I'd like to turn now to Dana as an advocate for veterans who are attempting to receive benefits. The previous speakers talked about their perspectives on potential issues that veterans may face. Could you give us your perspective on some of the more systemic policies effects of bad paper discharges? So, an inability for an individual to access VA health benefits or VA pension is a problem, but are there more systemic problems if veterans are trying to obtain housing or employment or access to services through veterans treatment courts?
I think many of the people who are tuning into this field hearing or on the task force know a lot already about veterans who have bad paper, so I don't want to go too much over the statistics about what we know about this population, but I will just say briefly, because it contributes to what the systemic issues are, is that all of the major challenges that face the veterans population, including mental health conditions, suicide, homelessness, incarceration, having bad paper just magnifies how difficult it is to deal with those challenges. And what we know about bad paper in general is that there's a really strong link between having a mental health condition in service and getting out with bad paper. There's a study about Marine Corps combat veterans with PTSD being 11 times more likely to be discharged for misconduct, 8 times more likely to be discharged for substance abuse. Military sexual trauma survivors also more likely to be kicked out because of either a mental health condition or in retaliation for trying to report that assault. And those mental health conditions then don't disappear at discharge. And in fact, for a variety of reasons, they may get worse. So in the veterans community of those who have bad paper, there are higher rates of mental health conditions and 3 times the rate of suicidal ideation if you have an OTH discharge. We also know that discrimination in service is a predictor of having bad paper, both on the basis of race and on the basis of sexual orientation. And we know that there are really disparate outcomes in the way that similarly situated service members get their service characterized. So there are disparities both across eras, where administrative, less than honorable discharges, OTHs general were much less common in the past and have steadily increased over time. And that also different service branches look at and deal with misconduct differently. So as much as there is a single DOTI that says, you know, an OTH is only for these serious types of misconduct, the fact is that a service member who uses marijuana once may get very different treatment if they are serving in the Army than if they are serving in the Marine Corps, than if they're serving in the Air Force or the Coast Guard. And then that has that downstream effect. Even though these members have similar service, it has the downstream effect on what benefits they're able to access. And so in some ways, who deserves bad paper is a little bit in the eye of the beholder. And I would quickly just share, just because I thought it was helpful to see the data. And this goes a little bit to Ron Flagg's question in the chat box. So we've seen this steady increase in the percentage of service members who are getting administrative discharges over time. Steady increases in OTHs as well as in general discharges since World War II. Which means correspondingly, there's this decrease in the percentage of veterans who are getting honorable discharges. So for all that veterans or service members have a lot of rights, perhaps, in the discharge process, the fact is that the procedures are not protecting them from getting out with bad paper that then causes them to be presumptively ineligible for VA benefits. And thus, this is that downstream effect of the way that DoD and the service branches are branding more veterans with less than honorable discharges means that higher and higher rates of veterans are being presumptively excluded from VA and never getting through the doors to the wonderful services that VA generally offers to veterans. And what we then see, sort of when we think about this, the cumulative effects, you know, the fact is that there is a process where a veteran with an other than honorable discharge can be determined fully eligible for most VA benefits, as Brian said. But getting through that is a really difficult and lengthy process. And so even if they get through it, there are delays in accessing care. And we know what happens with delays. There are people's health conditions get worse. They become harder to treat. There's delayed income support, which can lead to issues with losing housing or being unable to support oneself or one's family, foregoing you know, health treatments if you don't have access to health care. There are, as Brian also mentioned, sometimes some exceptions, as they are termed in the law, that allow access to mental health care or counseling or some not full access to VA benefits, but some limited access. And while that is certainly helpful, we'd much rather people get some care than no care. The fact is that I think, you know, going back to some of the first panel today, people are, I think, best treated when they're really given holistic services, and we don't see mental health as a silo, but that having access to physical health care is often a way into mental health care, and they sort of need to work in coordination. And that's something that VA often can be very good at, is having this sort of holistic treatment. So we want people to have access. And then the other situation is just many veterans never get inside that door in the first place. There's just a total total denial of care. And while that leads to all sorts of negative downstream effects, one of the important things to remember is that the cost of caring for this veteran does not actually go away just because the military and VA are not providing those services. They are pushed onto other systems that are otherwise might be less able to deal with it. Community organizations, local governments, prisons, Social Security, Medicaid, and what I so often see in my practice is people's families and friends. The number of parents I have had who called me because their veteran, got kicked out after returning from Afghanistan and is now living in their basement. They don't know what to do. That has happened many, many times. And because it becomes so hard to access these systems that are supposed to be there for veterans, that just contributes to this sense that veterans with bad paper are categorically ineligible, which is not the case. And it also contributes to this misconception that people who have bad paper are actually bad people, that they are people who are supposed to be ostracized, who are kicked out if they did something terrible. And the fact is that many of them did not, or there are truly compelling or mitigating circumstances that went around whatever it was that led to their less than honorable discharge. And we really want to be building a system where people come forward and access the resources that may in fact be there for them. And that is unfortunately not the system that we have right now.
One follow-up before I had the global question for the rest of the panels, which is you mentioned that the costs of treatment don't go away if a veteran is denied all or some level of services by the VA. They get pushed off onto other systems. Have there been any studies of what those numbers look like in terms of costs, like savings to the VA, but the costs that are then borne by city, state, municipal systems?
There are none that I'm aware of, although I would love to know the answer to that question.
I wanted to touch base with all three of you, having heard all of your perspectives, about the Veterans Task Force's charge, which is to identify legal issues faced by veterans, to improve veterans' ability to access counsel where necessary to address those issues, and to identify best practices for serving veterans with civil legal issues. And so I want to start with Major Stokes and with Brian. So to the extent that there is an answer for this, what would be helpful for veterans advocates to know about your respective parts of the discharge and benefits processes? And some of the things that I'm thinking about are, what would be the most important things for them to know before engaging with your organizations? Are there processes that you use to appeal? Are there forms that they should have? Kind of what do you see as the most important things for advocates to know if they're coming before you to appeal an adverse decision on behalf of their clients?
I wanted to just reiterate a couple of points before I answer your question. And the first one is that discharge is a process. I think there's a misunderstanding or just a lack of awareness about how this works. It's not as if a military member is in the Army, for example, today, and then tomorrow they're out. It's an extensive administrative process. And number two, it requires multiple levels of review. And so when a soldier, or I say soldier, but it could be a member. I just say soldier because I'm in the Army, right? But when a soldier is notified, well, first of all, something bad has to have happened. There has to have been a hot UA, there has to have been a misconduct allegation, there has to have been some sort of triggering event that justified separation in the first place. And then the commander needs to notify the soldier. The soldier's got 30 days to respond, and then it goes to the higher level of command for review. And then it goes to another higher level of command for review. And then it goes to a personnel shop for review. And then it comes to my office for review before it even goes to the separation authority for final agency action. And so it's not as arbitrary and capricious as one might think. The third point I just wanted to reiterate is that when we're talking about OTHs, which is primarily the one that hems people up the most. When we're talking about OTHs, like I said before, those are limited to specific types of misconduct or specific bases for separation. And then the next point is administrative separation boards are guaranteed for someone who is notified of an OTH separation. So again, it's not automatic. They are entitled to a board. And this brings me to my last point and where I want to engage on your question. Most of the members that we see waive their rights. So they receive the notification. It has all of the elements in it that I described previously. Notification of a right to counsel, notification of an entitlement to documents, notification of board process, et cetera. And most of the time, that member waives their rights. Now, I suppose we could quibble about why that is. You know, are they intimidated by their commander? Are they rushed to make a decision? Are they uneducated or uninformed? Do they just not care and they want to get out? I mean, there are lots of different justifications for that, I suppose. But I think that there's a gap there, and I think military members are making these decisions without being informed of the true understanding of what's happening to them. And I think the LSC and our civilian partners, our community partners, especially those that are around installations, can probably launch an information campaign or something like that to make sure that they understand what their rights are before they move forward. And I think that's the biggest issue, because if someone understands their rights and they invoke their right to an administrative board, they're entitled to a military lawyer, and that military lawyer will represent them at the administrative board. So there's really not a need for civilian counsel to assist them in that proceeding, but they can hire they can bring their own civilian attorney. So if LSC wants to train up a cadre of, or our civilian partners want to train up a cadre of trained administrative lawyers that'll come in and take down the man, then maybe that's a need that's out there. But those are that primary need is the fact that members mostly waive their rights.
Excellent. Brian?
I don't know that I have an easy answer to this. It's I guess just at the baseline that this is a complex system, and there are, I've said it before, there's a lot of nuance to it. And so making sure that you as the representative do the legwork and understand it and can advocate, effectively on behalf of your client, is no easy task, and I don't want to minimize that challenge at all. But I think it's important, and VA has authority to, like I said, with the duty to assist, to help and support, but and not just the authority, we have responsibility to do so. But that's not a substitute, or I think that works even better when there is knowledgeable counsel and they're supporting their client and helping them develop the claim, helping VA develop the claim, and the better that you can understand it, the better you can make sure that it goes well for your client. And certainly that's VA's role as well. And I don't mean to in any way sort of put this off as like, oh well, representatives need to do more. It's just if you understand it and you can help advocate for your client, you're going to help them get a better outcome. And I think one of the things that is just fundamentally at the starting point and key to understanding is VA can't change the character of discharge, but VA does have authority to do more and provide some benefits given the character of discharge. And that's limited. I'm not saying we have complete flexibility by any stretch. But if you're representing someone who is not getting the outcome they need or that you think is justified, one solution or possible response is to go back to the military. And I'm not familiar with that process, and I'm familiar with it in the sense that I've seen evidence of it multiple times, but I've never done it. And I don't mean to say that that's an easy process either, but there are different tools available and there are different responses. And I think that this is an issue that Congress has responded to a certain extent. And I think that, the statutes are better than they used to be. The regulations, I think, are part of this system as well. And VA issued a FR notice, a Federal Register notice of a proposed rulemaking, and the comment period just closed not too long ago, earlier in September. But some of this may be, changing, hopefully for the better in the near future on the regulation side at least. So I guess advocate and recognize that it's not easy, but one of the upsides is that there's a variety of things that can be done, even if it's not like Danny was saying, getting the full suite of benefits. And there really are a lot of benefits that are just, veteran status is pretty fundamental. It is key to, but there are some things at the margin that are out there. So don't give up, and be creative and advocate.
Dana, what do you see as the biggest gaps in service to veterans who are seeking access to benefits? So in other words, in your perspective and from your experience, where should the legal community be focusing its efforts? Is it on the processes to correct service records or obtain discharge upgrades, on character of service determinations, on, as Stephen said, kind of doing education maybe early on to assist members who may be facing an adverse, who may be facing an involuntary discharge that would result in an other than honorable status? Like, what are your thoughts?
I mean, I certainly would choose all of the above if I could, because I do think it's, the most important thing is to focus on, not having more people get pet paper in the first place. And so the separation process is really important, but there also are many wonderful JAG attorneys at TDS offices who will provide counsel. And so there is some access to lawyers. Although, as Major Stokes mentioned, a lot of people, for a variety of reasons, waive their rights to speak with lawyers. And maybe that's a systemic problem to look at, is why are people allowed to waive their rights to merely talk to a lawyer, to have a sit down. But I would say, the way that the legal aid community, I think the place where we often feel most comfortable and where we can make a huge impact is in doing both, VA character discharge determinations and discharge upgrades. And that's both, there's a lot of overlap actually. So, for most of my clients who have that paper, we're not choosing one or the other. We're just deciding, we're either going forward with both at the same time or sequencing them for some strategic reason. But there's a lot of overlap in the evidentiary development that you would do for a case. And so in some ways, although they are two separate matters and you need to know two areas of law, it's almost like 1.5 cases when you think about the actual caseload. So there's a lot of reasons, and they can have really beneficial effects to be on both levers at once. And then I think we do need to, think also about systemic advocacy about that paper and the way that, whether through engaging with local providers and organizations, we can really push back on this myth that veterans with that paper are categorically ineligible from benefits. And so doing sort of community workshops is really helpful. And then even just thinking about how do we, in doing the cases, can help, I don't want to sound patronizing, but almost think about the advocacy that we're providing as illuminating this area of law that I think is not a lot of people pay attention to. And so, for example, I'd say, we at the clinic where I work, we work a lot. We go to a lot of hearings at the Boston Regional Office, and we take a lot of character discharge cases. And there aren't that many people at the Boston Regional Office. So we see the same adjudicators over and over at these hearings, and they get used to what our spiel is about character discharge, and we've had really great success. I think they've come to sort of see the regulations and the way that it doesn't actually say, you have an OTH, you're ineligible. It says, here are the factors, and we provide you the evidence of the factors. And so we can sort of think about changing the systems within. And then I will say, as Brian mentioned, there was a comment period that just closed for VA revising its regulations about character discharge. And I just do want to give a shout out to the number of people who are on this call who wrote comments from law school clinics and legal aid offices across the country, because having that experience from being on the ground, I think is really valuable, and hopefully will mean that some of the systems problems might be a little bit better.
Thank you. That was helpful, and I appreciate all of your comments and thoughts. Those are very important to helping us figure out what our recommendations look like moving forward. I now want to open the floor up to questions, and I have a question from Margaret Kuzma. Margaret, do you want to pose your question?
It was for Major Stokes, and he talked about the different levels of review there are when somebody is going through being administratively separated. And I was just wondering if there's any data about how often it gets changed as it goes up through the level of review. So say you have an 03 who's 27 years old, has a ton of discretion as to whether he gives or she gives the OTH or the general or an honorable, because the level of misconduct could theoretically fit into either. How often does that change, that decision get changed as it moves up?
That's a good question. I don't have any hard data for you. I suppose I could speak anecdotally a little bit about that, though. I just by way of foundation, my office does a legal review on somewhere between 200 and 300 separation packets a year. And so we see a lot of these, and it is not unusual for a senior commander to override the recommendation of a junior commander. For the factors that you mentioned, right? You've got most 03 commanders are in their late 20s to early 30s. Most 03 commanders are relatively limited when it comes to experience in the Army, whereas their battalion commander is sitting at 15 to 25 years of service, and their brigade commander has even more than that, and our commanding general has even more than that. And so it's not unusual for a subordinate commander's recommendation to be overridden. That being said, there is quite a bit of deference by senior commanders to their subordinate commanders. And so as we've been talking about this, I've been thinking about how to engage with our commanders across our force, at least in my little corner of the Army, and make sure that they understand all the way at the lowest level what the ramifications are for their recommendations on characterization. Thank you. Over.
That was actually my second question, was how often, somebody like an 03 is trained on the ramifications, and if there is a possibility for, I know that having civilians come in and do training is usually not the most effective, but if there is a possibility for people to come in and talk about the ramifications of the different discharges.
I'm trying to figure out how to answer your question in a logical way. So there is a formal training, at least on the Army side. I can't speak to the other branches, but on the Army side, before you're allowed to take command, you have to take a class called the Company Commander and First Sergeant Pre-Command course. And in that course, there's a block on military justice and discipline. And I teach that block to all of our incoming commanders. And that's really my first crack at them. And then other than that, it's really when they call me with issues on an ad hoc basis. But I am going to formulate some refresher training that they can watch either on an annual basis, or maybe every couple of years, or some sort of digital training, but to be determined. Over.
Excellent. So I see we have some questions in the queue. Next question, it goes to Evan Simone. Evan, do you want to unmute yourself and ask your question?
Just very quickly, first of all, I'd like to thank Dana for her national leadership on this issue. It's been tremendous. And just very quickly, I think one point to emphasize is that the goal is hopefully to get the service member a general discharge so that they would be eligible for veterans benefits before they leave the military. So if you have a general, it's considered under honorable conditions. And again, aside from losing the GI Bill, you could be eligible for things like disability compensation and vocational rehabilitation. And I guess one of the areas where you can make the most impact is before it gets to the stage where they finalize a decision. So helping commanders make the decisions with more information, or helping the board make its recommendation to that commander. I would say that in considering transition from the military, an important thing to remember is, and again, I think Major Stokes really underscored this, there's a lot of process involved, and sometimes it could take years to finally process a separation. In the meantime, that service member is still in the unit. And too often, the service member is labeled as, hey, you're not going to be any value added. You don't drill with us anymore. There's stigma there. And oftentimes there can be increasing misconduct along the way waiting to finally get processed out. So one of the ideas would be as soon as it's identified that a service member is on the track for involuntary separation, that's the time to try to connect that service member with information as early as possible so that they can get their bearings. On active duty, the minute that an other than honorable is issued, the soldier or sailor or airman is usually given a bar that says you're committing a violation to come back onto post. Don't even come back. It's against federal law. And that's the same post where the service member was getting all kinds of medical, dental, everything they could want. Then they walk outside, and by the time they have that OTH, it's unfortunate. I've been with many, many soldiers where we've gone to a State Department of Veterans Affairs and they say, you've got an OTH, we can't help you, even at the state level. So the idea would be to try to do as much as possible before the discharge happens, including, if you're successful, to be able to persuade the separation authority or court-martial authority to give a better discharge that would make the person eligible for benefits. If you're not successful, to at least help prepare that person to make the transition as early as possible in the process while they can still take advantage of various services. Thank you.
Our next question is from Benjamin Pomerantz.
Great, thank you. Thank you for a great panel and a very informative panel. Question that I have deals with a topic that I'm sure all of you have grappled with, and Dana, I know that you have written about this in the reports that you've authored. It's the issue of access to VA medical care. In New York State, we've seen far too many situations, unfortunately, where the people who are the gatekeepers at VA medical centers have denied access to veterans seeking VA medical care on the basis of characterization of discharge, even though those individuals are in fact eligible for VA health care under existing federal law. So in those situations, what's the best advice that all of you have as far as the steps that advocates should take in that situation? If the veteran qualifies for health care services under the Honor Our Commitment Act, for example, and they're being denied at the facility level, what are the next steps that advocates should take in that situation? And thank you.
We see this all the time of veterans being turned away when they try to go to VA health facilities and try to seek access to health services that they should be eligible for. That is what led us to write the Turned Away report, and it was based on a lot of reporting from legal aid advocates across the country. So there are things we do in individual circumstances, like go accompany the veteran ourselves as a lawyer and help them sign up for healthcare, even though you shouldn't need a lawyer to sign up for healthcare. We would help them file a claim for some other benefit that better triggers the COD process, so that then they might get through the get approved either for full benefits or under Chapter 17, and go through the appeal system if we need to. So there are ways to fix it on the individual level in most circumstances. But there is a systemic question of like, why is it so hard for someone to get access to healthcare benefits that they're entitled to by law, and without having to go through CODs? And I think there are ways to think about dealing with that both on the local level of, having a meeting with the manager of the healthcare enrollment team and seeing if we can partner on training or talk about standards or better guidance that maybe you could engage with on your state or local level. And we're also hopeful that the national VA also might consider ways to more systemically address the problem by, for example, like updating the VHA enrollment manual, or just doing more training and guidance for frontline adjudicators to not play that gatekeeper role, to know when it is that, to think that we should really adopt a no wrongdoer approach. Like if you come forward to VA and you're seeking healthcare, like the job of the person on the front line is to figure out what form you need to get that process started, not to say that you aren't eligible.
Dana, thank you. A quick additional question, if I may. When you've gone to the VA teams and talked about having a training with them to focus on these issues for healthcare access, have they been receptive, or has there been resistance to inviting, lawyers in to talk about what the law says around healthcare access?
We have some really great relationships with our local VA folks. We have done trainings for their social work team, especially worked with many of their outreach team members. I don't want to go through the whole list, but I will just say we have generally found our local VA to be pretty receptive to talking to us and thinking through problems. I don't yet have I know people have a variety of experiences, but we have some wonderful folks on the ground. So, and I just want to make clear that, while there are many criticisms that I have about the way that the VA systems work, I mean, the fact is that my job is always like fighting to get people in, because I think the services they provide are really valuable and meaningful, and can be absolutely life-changing. And I've seen that happen. But Ben, I'm also happy to chat with you some other time if you want to compare notes.
That'd be great. I'd appreciate that. Thank you.
I saw that we had a question from Jesse Medlong, one of our DLA Piper associate colleagues who is helping us staff the task force. Jesse, do you want to unmute and ask your question, please?
Major Stokes had said that in his experience, it's quite common for senior commanders to overrule the decisions of lower level supervisors. And I was just wondering how, like, when you see that, if it's not uncommon, is it more common than for those commander overrides to take the shape of a worse discharge status or of a better discharge status for the separating member?
That's a tough question to answer. Because honestly, I've seen it go both ways. I've seen an O3 commander, a subordinate commander, recommend a very favorable characterization of discharge, and there's a sense from looking at the record, from looking at the commander's letter, from looking at the soldier's letter, that commander is trying to help a buddy out, and is not accurately reflecting upon the factors of consideration and the incidents of that specific case. I've also seen it the other way, where you've got a super hard charging O3 commander who views the world in a very black and white way, and is not interested in understanding the member's perspective, and they come down with a very harsh recommendation for characterization of service. And to be perfectly honest, I've seen it go both ways. And I think that's why there are so many levels of review, to include a written legal review that comes out of my office for each one of these packets, because we are supposed to review the recommendations in the chain of command, as well as the facts, of that specific instance, as well as the applicable standards, and give our recommendation to the separation authority on what he or she should do. So I don't have any metrics. I can just speak anecdotally about what I've seen throughout my career. And honestly, I've seen it go both ways. Over.
Excellent. Thank you, Major Stokes. I think we have only one more question. Mo Cedar, do you want to unmute and ask your question?
Yeah, sure. Hi, everyone. So my question is for Brian at VA. And it's in your adjudications, or in the adjudications that the VA decision makers put forth. How do they factor in the arbitrary considerations that Dana mentioned earlier, where the data, shows that Marine Corps vets are much more likely than airmen to get bad paper, or that recent era veterans are much more likely to get bad paper than those who served in Vietnam, and much more so for those who served during World War II. How does that factor in? And then also, secondarily, the issue of discrimination that Dana mentioned, where the studies, both government studies and others, have shown that there's higher rates of courts-martial and non-judicial punishment for Black service members and other service members of color, and how that increases their chances of getting bad paper. Does the VA consider that racial discrimination when they are adjudicating the eligibility determinations? Thanks.
So there's, I guess there's a really easy answer, and then, it borders on meaningless. It's, on a case-by-case basis, and it depends on the facts of the case and looking at the case and that kind of thing. In terms of systemic patterns and trying to establish that this is an example of a general sort of problem, and that rates are different for different offenses or for different people, or that kind of thing. There's nothing that I'm aware of in our statute or regulations that sort of specifically address that. But anytime it's brought up, then obviously we have to address it under the reasons or basis, and that's a general statutory requirement for VA adjudications. There's one thing though, which is you kind of touch on, and I think was touched on earlier as well, that I want to make very clear. Other than honorable and bad conduct discharges are not automatic anything at VA, and they don't preclude you automatically, an individual, from establishing veteran status. There's an adjudication that happens. And so if I understood one of the previous questions correctly, there are people that are showing up at VHA, Veterans Health Administration medical centers, and are getting denied based on, told we won't treat you based on here's my DD-214 and it's got an OTH or something like that. And I don't know at that level of specificity what VHA's policies are about if someone shows up and that kind of thing. And I don't want to speak to that because I just don't have knowledge. Most of the work I do is with DVA, not VHA. But if someone shows up and they have an OTH, or they don't show up and they're just seeking guidance on generally whether or not they can get healthcare or something like that, the fact that they have an OTH or a BCD is not going to answer that question, or it's not going to be the end of the conversation. Because, as I said at the start, and I'm sorry, we're after 4 o'clock, and I'm making this run long, so I'll try to be brief. But as I said at the start, there's a lot of nuance here, what Congress did for DoD and what Congress did for us don't match up. And so, it's pretty rare that someone's going to get benefits if they have a dishonorable discharge. Although even that, there's an exception to every rule. So, and that has to do with insanity, and we're already over. But I would say that I don't see any basis for categorically saying that OTH or BCD means that you don't get veteran status. And in an individual instance, if your client's being told that, then there's an appellate process, and obviously advocate for him. I guess. Sorry for running this long.
Thank you, Brian. And then we have one last question that we were not able to hear our speaker earlier, so I'm going to go ahead and ask it for them. The question is for Dana, and the question is, what has been your experience with the Veterans Justice Courts? Does bad paper affect how vets are treated in these specialty courts? Excellent presentation, thank you.
So yes, having bad paper does impact the way that veterans treatment courts do operate. It depends, in Massachusetts, bad paper isn't a bar to get it to being eligible for the treatment courts, but that's not the case in many states, in part because I think the veterans treatment courts very much rely on the resources of VA, the VJOs and the mental health support and the other resources that VA provides. And so if there's either a perception of veterans with bad paper being ineligible, or they're just having difficulty getting them into the system, I think many states have actually just cut it off and say, you're only eligible for VTCs if you have an honorable or a general, because those are the ones we know will have the resources to be able to do this really intensive program. And so, expanding the way that veterans with bad paper, helping them get greater access to VA may be also a way to help them get access to some of the supportive resources and benefits of VTCs.
I want to thank our panelists for giving a terrific presentation this afternoon. That was extremely informative. I'd like to thank all of our questioners who asked a ton of questions. And I now want to turn the floor over briefly to our president, Ron Flagg, for a few brief closing words before we go into the closed session for the task force members.
Thank you, Stephanie. And thank you, Brian and Dana and Major Stokes. And your presentations were informative and thought-provoking. And many thanks to all of today's program participants and speakers, and to our DLA Piper colleagues for your partnership on this task force. I'm going to cut my closing remarks short because we are running a bit behind at this point, and I want to give the task force a full chance to debrief on what we've heard. But I think we have a number of goals for the task force, and all of them have been advanced by today's field hearing. Happily, this will not be our last field hearing. We have another one scheduled in November. Please stay tuned for further details on that. Lastly, a point of personal privilege, if I might. I'm speaking, of course, today as president of the Legal Services Corporation, but I would be remiss if I didn't also mention the National Veterans Legal Services Program, one of the premier programs providing free legal services to vets across the country. And I had the privilege of serving as chair of the NVLSP board for the last, I think, 15 years or so. Bart Stichman, who's the executive director of NVLSP, is also a member of the task force and with us today. So glad to have you, Bart. Thank you for tuning in. And special thanks to everybody who shared various resources with us. We look forward to seeing you in November. Thanks to all of you. Stay well.